Okay.
So
My at the end of January, and he lived in Texas. My half sister is the executor. The attorney that she got when he was still alive for his will and everything is saying that we need to have like $10,000 in account separate so that if there's any other hospital bills or anything, it can be paid out of that. But I know here in Florida that if you have two forms of insurance, that the hospital does not expect you to pay anything over and above that. I tried to go pay a bill one time at Gulf Coast Hospital, and they wouldn't accept any money from me because they had already collected on two of my insurances. And I wanted to know, is that something that's just state to state? Is that nationwide? Does that sound like something that people do all the time, is save money in account?
Yeah, Belinda, I want just a second. Let me get the first part of it. Who was it that passed away? Was it your father?
My father, and he wasn't married. So.
Okay. And he passed away in January?
End of January,
Okay. And it's you and a half-sister and how many other siblings?
Well, it's five of us all together, but just one of the sisters is the executor. And I guess she and he went to this attorney before he passed away. I guess this was a couple of years ago, and made up his will. So now that attorney is asking us to keep $10,000 in an account just for any other, like, hospital bills or anything like that.
Okay, so it sounds like your father did have a will and it has been probated out in the state of Texas?
Yes, it's nothing's finalized yet. We've got a couple of assets that we're trying to, get the appraisals on and try to go through the proper process and everything.
Okay.
Also,
yeah, let me interrupt you right here. So setting aside the $10,000, that's just something that's prudent to do if you're making an early distribution. Typically, the way an estate works and operates in probate is there's not really a distribution until there's a final distribution after all of the creditors have been notified, after all of the properties have been sold, and then at the very end, you can go ahead and sign off on everything and divvy it up the way that the will decides to do it. So it sounds to me like the attorney is trying to make an accommodation, and this varies from attorney to attorney, quite frankly. It doesn't just vary from county or state to state. And so in this particular instance, the attorney has made at least an educated judgment to hold back $10,000 for potential creditor's claims or cost, and that's kind of a prudent thing to do. And the reason why is, let's say that even though he may have given notice, he may have given direct notice, if somebody files in something into the estate called a creditor's claim, and it happens to be valid, then tracking down the funds, if they're divided up among many parties, as you know, some siblings are going to be smart with their money, some are going to put it in savings account, and the moment some others are going to get their money, it's going to be spent before they got it. And so what the attorney's doing is mitigating the potential damage or the potential liability, to the executor of the estate, your half-sister. So that's just kind of a prudent thing to do, is set aside a certain amount of money in the event that there are claims. Not that there's likely to be a claim, but in the event that there is a claim or there is a claim that needs to be disputed, then it's there. I'll give you a great example. My mother-in-law passed away last year. We are still getting medical bills, and those medical bills are coming in, and we write back, she is deceased, she died with no money, there's nothing to probate, but we are still getting new medical bills about 9 months later. We're still getting new medical bills, and some of these medical bills date back 2 years ago. So that's to do. So what's the second part of your question, Belinda?
Okay. Well, the second part was that also I can't believe he did not have burial insurance. We paid for the whole thing out of the checking account that he left that she could write checks out of. And then when I had my other sister ask, because she went to one of the appointments, and ask, what about an asset search? Shouldn't we do an asset search in case he had, insurance that we didn't know about, or even assets that we didn't know about? We know about maybe like some CDs and a couple of accounts, but he had worked hard all of his life. He said he was going to leave each of his kids a millionaire, but I don't think he knew he was going to have 5 kids.
Right.
But so anyway, I was wondering, would it be worth it to do an asset search?
Yes, ma'am. In that particular situation, it sounds like there's sufficient funds available in the estate to cover that, and you should do that. And one of the things that you could ask the attorney to do through the executor of the estate is go to the credit bureau and see if there are any open accounts at the credit bureau, and that's a great way to do it. Now, the question becomes, what happens if we close out the estate and we later learn that, you know, hey, Dad was right. I mean, we got $1 million sitting over here in a TD Trade, Ameritrade account. Guess what? The state then will take possession of it and notify the executor of the estate, and the executor of the estate can then make the claim if there is something that is missed. But it does sound like something very prudent to do on your part as well, Belinda. Go ahead and make the offer or make the suggestion to the attorney to go ahead and do that, and just run a simple asset check through the credit reporting agency, and you have to do that through the executor of the estate. The executor has to sign off on it and do it. It costs a few $100, but it's well worthwhile to do that.